Mr. Chairman, thank you, and thank you sincerely for holding this hearing. But I got to tell you, the frustration is it is very frustrating. Let's remember why we're here. We're here because you had 2 duly issued subpoenas to the commissioner of the IRS, and they did not fulfill those subpoenas. In fact, they destroyed that evidence. The IRS, which issues on average 66,000 subpoenas and summons a year, they know how to dish it out, but they don't know how to take it. Imagine if you came back to the IRS and said, I had those documents, but you know what? I went ahead and destroyed them. Do you think that you would go to court or not go to court? Would you be in jail or not be in jail? We're talking about removing somebody from office. The duplicity and inconsistency for Mr. Nadler is stunning. He complains about censure, and yet he co-sponsors resolutions of censorship on George W. Bush. He does censures on Mr. Cheney, but heaven forbid we get rid of somebody who lied to Congress. When you provide false testimony to Congress, is that or is that not a crime? Is that or is that not against the law? Does any one of you think that providing false testimony to Congress is not against the law?
It really depends on whether it's intentionally false if you're talking about the criminal law.
But it doesn't rise to that level, does it, in terms of if you provide false testimony to Congress, is that an impeachable offense?
I would say that in the Senate Judiciary proceedings with respect to Attorney General Gonzalez, the senior members of the committee of both parties said that the issue was that the committee had lost confidence in the ability of the attorney.
So let me read, and I'm glad Mr. Nadler referred to, let me read a couple of things that Mr. Nadler cited in the 1974, he cited as the leading authority on this. This is from the 1974 Judiciary Committee report. Impeachment and criminal law serve fundamentally different purposes. Impeachment is the first step in the remedial process, removal from office and possible disqualification from holding future office. The purpose of impeachment is not personal punishment. This goes from the conclusion. The emphasis has been on the significant effects of the conduct, undermining the integrity of the office, disregard of constitutional duties and oath of office, arrogation of power, abuse of the government process, adverse impact on the system of government. Clearly, these effects can be brought about in a way not intended by the criminal law. And finally, and the other one I'd highlight is Mr. Madison. James Madison of Virginia argued in favor of impeachment, stating that some provision was, quote, indispensable, end quote, to defend the community against, quote, the incapacity, negligence, or perfidy of the chief magistrate, end quote. So the reason that we're here is because we had 2 duly issued subpoenas that were not abided by. In fact, they destroyed the evidence under his watch and then provided false statements to the United States Congress. Don't pretend that this is just some accident that happened over on the side. And certainly I think that Mr. Koskinen had a duty and obligation to inform the Congress when he do. Because what did he do? They informed the White House, they informed the Department of Treasury, but they didn't inform the Congress. And I have a problem with that. Now, Mr. Gerhardt, you argued that the CRS report would say that that Mr. Koskinen maybe doesn't rise to the level of somebody who is impeachable. Do you believe or not believe that the commissioner of the IRS does qualify as a civil officer?
Sir, I could have, I'm not sure I understood the first part of what you said, but I think he has enough responsibility, as I said in my opening statement. I think he exercises a substantial enough authority where he qualifies as.
Does anybody believe that the commissioner of the IRS is not of a significant high enough level to be qualify for impeachment? Very good. Let me also highlight something that about this range of offenses. Mr. Gerhardt, in 1999, you wrote a law review article that seems to be in direct contradiction to what you said here today. Today, your testimony is, quote, indeed, the founders considered but rejected making certain high-ranking officials impeachable on broad grounds such as maladministration. But in 1999, you wrote, Mason therefore withdrew his motion and substituted other high crimes and misdemeanors against the state, which Mason apparently understood as including maladministration. So which one was right? Were you wrong in 1999 or are you wrong today?
I'm describing George Mason in the one you just quoted from.
Yes.
But in fact, what he understood, it wasn't necessarily attributable to to the entire body. In fact, they adopted the phrase at the convention. They specifically adopted the phrase other high crimes and misdemeanors to distinguish it from maladministration. So, number one. Number two, over time, I think other crimes or misdemeanors have grown to be understood as requiring both bad faith and a bad act.
And clearly, Mr. Chairman, I think there were more than just that. Providing false testimony, not complying with the subpoena, in fact, destruction of evidence does qualify, in my opinion. Yield back.